Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-3061, United States of America versus Jane Browne, appellant. Mr. McCoby for the appellant, Mr. Burney for the appellee.
Good morning. May it please the court, Max McAbee for appellant Shane Browne. Your Honor, we urge this court to find that trial counsel below was ineffective and that it made a difference in the outcome of the case and to remand for a new trial. We submitted what we believe is more than enough to show that to overcome the strong presumption that any of the errors that we allege trial tactics. Just to start with the two elements, ineffective and then prejudice. The government does not dispute that the case depended on a sole witness who was impeached on major points, that he had a motive to fabricate, and there was absolutely no corroboration to this single witness, the Lyft driver. Therefore, any one of ineffective assistance of counsel claim could make a difference. We submit that there was a complete failure to investigate. The government says, well, it was trial tactics. It was a pure reasonable doubt strategy. Well, you don't reach that if you don't interview critical witnesses to the case who can directly impeach Mr. Flores, the complaining witness, the Lyft driver, on key points, including whether there was an argument at the trunk of the car in the McDonald's parking lot, whether there was an argument in the car. These are points where Mr. Browne was on the phone with a friend who overheard and could have testified there was no argument. Well, the decision not to call him as a witness can't be a trial tactic if trial counsel admits he never interviewed that witness, Mr. Keslow, in the first place. That is what under the United States versus Mohammed says is a complete failure to investigate. Moreover, it's abundantly clear that there was ineffective assistance of counsel with the drugs. No effort was made to file a motion in limine to suppress 78 pounds of marijuana that was found several days later in his apartment in a search for the gun, because trial counsel said they didn't think they could win. Well, that's not a trial tactic. And they would have won. Some of it would have been suppressed. Nor was there a trial tactic in failing to object to 78 pounds of the noxious fumes of marijuana published to the jury, where the government prosecutor actually warned the judge and everybody in the courtroom that it was going to be an overpowering smell. They decided not to object to that because they thought it would be funny to the jury to see all those drugs and endear the jury to Mr. Browne as a bumbling, incompetent criminal. That can't be a trial tactic that's acceptable to this court. And it is contrary to decades of accepted defense doctrine to object to prejudicial evidence. That's the whole point of a trial. Defense objects to prejudicial evidence and the prosecution tries to introduce it. Yeah.
When this case was first on appeal to this circuit, we remanded for further factual findings on the ineffective assistance claim. The main focus of our panel opinion was on these Miranda claims. What happened to those below?
So,
I mean, that was the main focus of why we had remanded, and then I didn't see much about that in the record.
The Miranda warnings were not given, and in the video with the detective, he made some points that were put in an affidavit for a search warrant. So ordinarily we would move to suppress. However, Mr. Flores also made representations for the search warrant. So under a independent source doctrine, the government may have been successful against the search warrant. So if you strike out the language with Mr. Browne from the failure to Mirandize him and just question him, even though he asked for a lawyer, he did ask for a lawyer in the video, and the detective questioned him for another 40 minutes without getting a lawyer. All of that, if you strike that out of the search warrant, you still have the complaining witness's claim that he had a gun and he pointed at him and he ran into his apartment. So it just wasn't, I looked at it closely. Now, what we did find when we remanded it for evidence was the results of the cell phone search, in which trial counsel clearly never read. It was only produced 2 days before trial. We know they didn't read it because it had people like Bryant Sands as witnesses in the call logs, and they never interviewed Bryant Sands on the way up to Aberdeen. Well, that tells you they didn't read it, the search phone results. Now, I read them when we remanded it. I got all the evidence, I read it, and I was shocked to find that there was a call log with 3 witnesses, Bryant Sands on the way up, and on the way down, Jordan Keslow and his girlfriend, Katie Impellizzeri, that accounts for an hour and 15 minutes of the 1 hour and 20 minutes when he was supposedly pointing the gun. It's accounted for. He's talking to Keslow for a good 30 minutes. Then he's looking at these adult web searches for another 30 minutes. And then he's talking to his girlfriend for 14 minutes. All the while he's pointing a weapon. Well, I didn't know that until I looked at the evidence and realized that there's no way defense counsel could have read those call logs and the text messages and the web searches and figured this all out. Also, it's clear they didn't read the fact that Flores had been charged with overstaying his visa for 10 years and was about to be, and was charged, fingerprinted, and arrested. They didn't know that. They said that in the ineffective assistance of counsel hearing. They didn't realize that. Well, if you don't realize that, it means you didn't read the discovery. Now,
you're also pointing out that there should have been certain witnesses called. And this seems to have been a trial strategy to essentially cross-examine and attack the government's witnesses as opposed to putting forth a case. Because you seem to be focusing on not interviewing witnesses, not, calling witnesses, but the trial strategy was to attack the government's case, not putting forth a case.
Right, and I'm submitting that you can't have that trial strategy if you don't interview them in the first place under the line of cases of US v. Barber or US v. Muhammad. You can't have a trial strategy if you don't know what the witnesses say. I mean, it's hindsight and convenient to later say, oh, we had a pure reasonable doubt strategy. We weren't going to call them, but you can't have that if you don't do the work in the first place, just like they didn't do a number of things in this case. Now, what they should have done with the discovery was ask for continuance, but they didn't. They just went ahead with the trial. Now, the pure reasonable doubt strategy is extremely tenuous in itself because they never actually argued it. In closing argument, they didn't say, ladies and gentlemen, the defense has no burden of proof. We have no burden to offer evidence. They didn't argue any of that. In fact, they uttered the words reasonable doubt twice and not in any context that would project any reasonable doubt strategy. That is an after the fact convenient excuse for not interviewing witnesses and not presenting evidence. And also the other thing is, let's assume they had interviewed for the prejudice argument, Mr. Keslow and Mr. Sands and Ms. Impellizzeri. All the people that account for 1 hour and 15 minutes of 1 hour and 30 minutes when he was supposedly pointing a gun the whole time that he couldn't describe, by the way. And the government actually had to describe the gun to the jury in leading questions because he couldn't do it.
But you also have to show likelihood of a different result.
Yes.
So how are you able to do that?
We submit that there's a strong likelihood there would be a different result because he was so badly impeached. I mean, he was impeached he told the police that Mr. Browne approached him in the parking lot with the gun brandishing in the parking lot. When the McDonald's video came out a week before trial, he changed it to, oh no, he pointed the gun in the car. Well, how did he get that wrong? Unless you're just making this up. He was impeached on that. He was also impeached on, he said Browne approached him in the parking lot with the brandishing the gun and forced him to open the trunk. Well, in the video, it shows Browne walking in the parking lot, babbling on the phone with his friend Keslow, and it shows Mr. Flores opening the trunk for him. Well, why? Because Mr. Flores waited 17 minutes in the parking lot for no good reason, clearly to drive Mr. Browne home from Aberdeen. He's not going to take a Lyft drive all the way up to Aberdeen, an hour and a half from DC, and not be paid to drive back. So what does he do? He waits in the parking lot. During that wait, he talks to his wife. He admits on the witness stand a couple times and his wife got a U visa as a victim of violent crime and got to stay in the United States. He was going to be deported to El Salvador, which is extremely violent, horrible country to be deported to. And what? He saw an opportunity. This is a young black man. He smelled the cannabis. He had a suitcase. I mean, if you're going to pick somebody, that's the guy you pick to make up an armed kidnapping case. You just make it up. And so he thought about it, 17 minutes in the parking lot, and he's like, okay. And then they drive back. Meanwhile, Shane Brown's babbling on the phone with his friend, Jordan Keslow. He's babbling with his girlfriend. He's looking at pictures of naked women. An hour and 15 minutes. I mean, the idea that if Mr. Keslow had been called as a witness, who is a cinematographer in Hollywood, no criminal history, he has highly impressive movie credits as a cinematographer, he would have testified to say, no, there was no argument. I overheard this. No, there was no argument at the trunk of the car. No, there was no argument inside the car. There was not, and also he would project a normal conversation. That's the other thing why it would have made a difference. They would project a normal conversation about life. They were talking about cryptocurrency. If a jury hears all that, just a normal conversation with 3 people, the idea that it would sway one juror to make a difference in this case is extremely compelling. And not to mention the 78 pounds of marijuana in front. Thank you.
I see you're out of time. My colleagues have any questions? Thank you.
And good morning, Your Honors. May it please the court, Kevin Burney for the United States. I'll focus my oral argument just on most of the points that appellant just brought up, but I just want to, at a broad level, say that I think with all of these issues that he is raising, the record shows that defense counsel was aware of them and made reasonable choices for all of their decisions. And that is all that Strickland and the Sixth Amendment requires.
How can you make a reasonable choice when you haven't talked to the person who would be the subject of discussion?
So, Your Honor,
Your effort to suggest the trial judge made a finding there, at least for me, doesn't convince me. The trial judge was not accurate in suggesting that defense counsel had made a decision based on any conversation with Keslow. That's just not accurate. But in any event, I don't know how you can make a reasoned choice as defense counsel if you haven't talked to potential witnesses.
So, Your Honor, I think appellants on appeal is arguing that counsel never talked with Mr. Keslow.
Right.
That is incorrect.
That is not incorrect. I mean, I looked at your attempt to deal with what the trial court said. The trial court's attempt to give you some help, I find totally unpersuasive. There's nothing to indicate that defense counsel had any reasonable conversation with Keslow and went through what any good defense counsel will do in talking with a witness. And
Your Honor,
you just don't have it, in my view, in the record.
I understand that Your Honor disagrees. I mean, I would respectively disagree with Your Honor. Could I just make the record for why I disagree, understanding, of course, that you do disagree. I mean, I'm looking at JA 966, and Mr. Fairley says, I spoke to Jordan at least once, I think maybe twice before trial. There's some follow-up questions about, what did he...
He also said, if he said I didn't talk to him, I didn't talk to him.
But I think the wording, I think the exact wording of what Mr. Fairley says is important, because the question is, Mr. Keslow testified that you did not interview him on the conversation as to what was said between him and Mr. Browne. Would you dispute that testimony? And all he says, if he says that I didn't, then that could be accurate.
Well, I don't understand. How can you possibly say that that's persuasive evidence in support of your position if the person being accused says, well, if he says that, and it could be accurate, a defense counsel who has interviewed or talked with or investigated a potentially critical witness, at least in my experiences, does not forget it.
Well, Your Honor, I would say that Mr. Fairley said several times that he was testifying 4 years after the events in question. And this is a factual finding that the district court made.
That's right.
He spoke with
the district court. I'm not going to go over the exact words. I'm just telling you, having carefully read what the district court said, the district court finding to the extent that it is a finding, doesn't hold up. He's not clearly saying that defense counsel clearly investigated this potential witness. That's not what the district court said.
Well, the district court does say on, I'm looking at 1192, note 2. The witnesses might be saying, Kessler being included in the witnesses here, that they never participated in a formal interview with counsel. The evidence does not support that allocation. Based on the facts noted above, and the district court is quoting some of the quotes that I just said, counsel's conversations with the witnesses were clearly substantive. The court will not quibble on semantics, i.e. conversation versus interview. The court credits trial counsel's impression of the status of these interactions, not those of the lay witnesses. So that would be
credit.
That would.
Those said he was never interviewed by trial counsel.
Kessler says that, but there are many times when the district court credits Fairley and Califat over Kessler. And even says specifically,
counsel said, I did interview him, and then I made an informed judgment as to whether to use him or not. Where is that? I'm missing it.
So first of all, on the first part, when he says, I spoke with him, on JA 966, I spoke to Jordan at least once, I think maybe twice before trial. Then the follow-up question is, and did you interview him as to what he said to Mr. Browne and what Mr. Browne said to him on the call? Answer, I don't recall with 100%, specificity. I'm sure we did. I'm sure I said, what did you guys talk about?
Yeah, and then the claimant says it never happened. And when defense counsel was asked about him, he said, well, if he says I didn't interview him, I guess I didn't.
No, but he doesn't say that exactly, Your Honor. He says, I can't.
He says something to that effect, right?
But I think the exact words are very important, Your Honor. He says, this is JA 967 to 968. Again, I can't be certain. I went back through my file. I don't have notes on what Jordan and I talked about, which implies right there that they did talk about things. So if he says we didn't talk about it, then that definitely could be accurate. Mr. Fairley, throughout his testimony, is stressing that this happened 4 years after the fact. And he doesn't remember all the details of these conversations, but he remembers that he spoke with Kessler. And he says, I'm sure I would have discussed what Mr. Browne and they talked about.
You're getting a lot more out of it than I got.
But let me just say this to wrap up my points on this. I understand the passages that Your Honor is looking at, and I've obviously put forward the passages that I'm looking at. But the district court made a factual finding, and that factual finding would be subject to clear error. Appellant has not even argued on appeal that the district court made clear error with regard to that finding. That is a factual finding. And appellant has to show that there was clear error. Now, this court recently said in Antonio, under that standard of review, a factual finding that is plausible in light of the full record, even if another is equally or more so, must govern. That's Antonio at 955, 63 F 4th, 948, 955. So perhaps one could read the record and even say it is more plausible that Fairley did not speak with Kessler. That would fail under this standard of review.
The court credits trial counsel's impression of the status of these interactions, which to me means it includes trial counsel's indication, well, if he says I didn't talk to him, then maybe I didn't. You can't get anything more out of it. You're talking about clear error with respect to that.
I would
quibble.
But right before that,
counsel's impression was, if he says I didn't talk to him, then I didn't talk to him.
But right before that, the district court says, based on the facts noted above, counsel's conversations with the witnesses were clearly substantive. That is a factual finding that has support in the record.
Counsel, it is not substantive in the sense that it's telling me anything. Substantive with respect to what? Because the trial court goes on to say what I just said, counsel's impression of the status. So where's the substance that supports your claim that counsel investigated this witness and clearly made an informed judgment that let's just let the government put in their case and we'll sit and we'll say they haven't met their burden? Where is that?
I would take two parts of the record and combine them to answer that question. First of all, on JA 966, Fairley says, in response to a question as to whether he discussed with Mr. Browne what Mr. Browne said to him on the call, he says, "I'm sure we did. I'm sure I said, what did you guys talk about?" Then when it comes to whether he made an informed decision based on that, at the hearing, Mr. Fairley testifies, and this is on JA 1022 to 1023, about the decision not to call Kessler, the decision not to call him. Not that he was just, it never occurred to him. He was just not thinking about it at all. He didn't know about it. So just sort of generally, it wasn't worth it, I guess, would be the best way to put it, to water down the reasonable doubt defense by calling a witness with marginal value at best. So counsel made an informed decision based on what they knew. And I would just point out too, when counsel is making this decision, the record reflects that even Mr. Browne did not think that Mr. Kessler was important. JA 799, Mr. Fairley says in his declaration, Mr. Browne did not feel strongly about calling Mr. Kessler. So appellant is saying, well, it's easy after the fact to rationalize all of this. Appellant is trying to, after the facts, point to small details that even Mr. Browne did not think was important at the time to try to get a new trial in this case. I see my time has expired. We've obviously spent a lot of time on Mr. Kessler, but I'm happy to answer any other questions.
With respect to the marijuana and then the comment about the naivety of defendant in that regard, how do you tie that together about bringing in that much marijuana, that kind of smell, that odor, and then say that, well, we were just trying to have a picture of the defendant being naive?
Well, I think it's actually effective. I think it was effective. Three people, both Califat, Fairley, and the district court presided over the trial, confirmed that the jury was amused when the marijuana was rolled in. So appellant is saying, well, it had a noxious smell. I mean, there's no evidence in the record that the jury was offended by that or that they thought it was noxious. They were amused by it. The reason why—
Used in a way that was favorable for the defendant?
Yes, because it's not—
I don't know how you conjure up this notion. You have piles of marijuana and claim as well that the jury seemed amused. Amused like, we're going to put this guy away a long time. I mean, it's not amusing. There was no attempt by defense counsel to in any way mitigate what was damning evidence sitting there in piles. No attempt whatsoever.
So, Your Honor, I think the word amusing, we haven't talked about how the jury, they seem to be amused, but the point is not whether the jury thinks it's funny or not. The point is whether it makes—
Your point, not my point.
Well, I'm trying to say, the point is whether it makes Mr. Browne look naive. Because he has all of that marijuana sitting in his apartment where anyone can smell it. When the police executed the search warrant, they could smell marijuana coming out of it. He's hiding them in suitcases. He's not elaborately hiding this marijuana. So if Mr. Browne is that naive, he's not a hardened criminal. He is not going to hold a gun to somebody's head in the car. That's the defense theory. And that defense theory seemed to have been borne out because the jury acquitted Mr. Browne of every single gun charge in this case. They only convicted him of the non-gun charges. And if he had been convicted of 924C, he would have had a 7-year mandatory minimum on top of everything that he is serving now. So the point of this, I would just say in discussion, is not to decide what is the best choice amongst all of these decisions that defense counsel faced. It's only to decide whether defense counsel acted reasonably. And on this record, especially given the many favorable outcomes that Mr. Browne ultimately received, we would submit that this court cannot find that trial counsel was so unreasonable as to violate the Sixth Amendment.
But do you at least have that the marijuana in the form that it was shown to the jury would have made the kidnapping more probable, that there might have been a sense of propensity evidence there?
I think it makes the kidnapping more probable in the sense that he is in a hurry and needs to get back to his marijuana stash. But I think there would have been plenty of other evidence that he was a marijuana dealer. There's no disputes that at trial it would have come out that he was a marijuana dealer. And this court has essentially said that in its previous decision on the direct appeal. So I think any prejudicial harm to him would be very slight. And meanwhile, it feeds into this larger defense strategy to portray him as naive and unable or unwilling to brandish a gun. Thank you.
Mr. Bernie. Jacoby, we'll give you 2 minutes for rebuttal.
Good morning again. I just want to make a couple points. It cannot be this court's decision that it is acceptable not to object to overwhelmingly prejudiced evidence. It can't be. Overwhelmingly prejudicial evidence. I mean, the 78 pounds of marijuana, even the judge said you can offer photographs. You don't have to just put it in front of the jury. I mean, he said that on the record. Not objecting the 78 pounds in front of the jury and where the prosecutor warns of noxious smell in favor of a photograph is a trial strategy. And society has enough problems. A jury is going to hold it against a bumbling criminal as much as a malicious criminal. I don't know how they distinguish between bumbling and naive versus malicious or nefarious, but the government somehow says that a trial tactic by a defense attorney that distinguishes between nefarious and bumbling is going to make a difference with the jury. Jury's not going to make a difference. Jury's going to hold it against him. They're going to say, we want to bring order to society, and we're going to hold it against somebody who's bumbling like that. And if they had seen pictures, especially with marijuana being legal in the District of Columbia in certain portions, if they see pictures, it's going to have a completely different effect than a huge spread in front of them. $36,000 was spread in front of them. I want to say about Mr. Keslow, the evidence is undisputed that he did not interview. It's not a question of what standard. I mean, the standard is de novo by this court. No deference is given to the district court, but it is undisputed. And when when the defense attorney said that on the witness stand, he said, look, I don't dispute it.
But in this court, and I looked at cases where we have actually granted ineffective assistance of counsel just to kind of take the temperature of the court. And in the Loeffler v. Cooper decision, where it showed that there was a discussion about a plea deal with respect to intent to murder, and then the counsel advised that you probably wouldn't get murder because there was shooting below the waist. Then the court found that deficient and defective because it's actually wrong advice. Another case, United States versus Knight, in which the client was incorrectly advised that the plea offer came with 10 years in prison, and then he rejected the plea offer and then actually got way more time, 22 years in the case of one defendant, 25 years in the case of another defendant, and again showing that the advice was actually erroneous. So help me out with, we're talking trial strategy, and then these cases where this court has said, yes, that's ineffective assistance of counsel, seems to be with actual erroneous advice.
Your Honor, I would just direct the court. I mean, we have erroneous advice here, like not advising on a blind plea to try to suppress
But there's information in the record that the plea was never offered.
Yes, they admit we never recommended a blind plea to try to move to limit or suppress the 78 pounds of marijuana. They say that. That's just bad advice, and it cost them a responsibility penalty for sentencing. But other than that, I would just direct the court to look at US v. Muhammad and US v. Barber, where they just, they call it a complete failure to investigate. When you don't interview critical impeaching witnesses,
But wasn't
especially good
not
witnesses.
Interviewing any witnesses completely failed to investigate?
Yes, it's a complete failure to investigate. By their concession, they didn't interview Mr. Keslow. They didn't interview Mr. Sands. They don't dispute that. And he's on the call logs. You don't understand how important these witnesses are unless you read the call logs and say, oh my God, all the times match up to the armed kidnapping. Maybe he didn't do the armed kidnapping. Let me interview them. If you don't read those call logs, you don't understand the significance, and they clearly didn't read it. It's just a pretrial failure to read the materials has to be assessed against them, and it can't be a trial strategy. And I just want to emphasize a couple things. First of all, in that Muhammad case, my colleague here said it mattered because Mr. Browne wasn't emphatic about interviewing Mr. Keslow, and he wasn't that great a witness. Well, Muhammad makes the point that says even if the defendant's depressed or despondent or doesn't think that trial counsel should interview anyone, that doesn't matter. Trial counsel has an independent duty to investigate no matter what defendant says. And I also want to emphasize
Let me ask you one thing.
Yes.
Opposing counsel suggests that you don't make the claim that the finding the district court was clear error. I'm looking at your brief again. I obviously surmise that appears to be exactly what you're saying, that the factual findings were clearly erroneous. What is your response to them? You're not stating it the way counsel stated it, but do you think you raised the clear error objection? That's your responsibility.
Absolutely, Your Honor. We raised the error by putting it directly before the court and to dispute the district court's finding, and we asked that it be over. It's one of our claims. I mean, it's a claim before this court, and our claim before the court is that there was a complete failure to investigate by interviewing Mr. Keslow. We put it before the court. They opposed, and we were arguing it here before the court. And the first appeal did have pretrial and failure to do pretrial investigation. That was in the first appeal, and that was remanded to develop a record on that. And so that is properly before the court. I also want to emphasize that what a close call this case was. So single witness, any one of these factors would have made a difference. Moving to object to the 78 pounds would have made it. And we know it was a close call because the jury was deadlocked except for one count, which had to be the unopposed count 3. Deadlocked. And it was a compromise verdict. They found him guilty of kidnapping without a gun and not guilty of kidnapping with a gun when the only threat of force was the gun. Well, that's a logically inconsistent verdict. That would be error if it was by in a bench trial by a judge. But it's a compromise verdicts are allowed by juries in our system, or juries under our system. But it shows with a deadlock that any slight difference would have made any one of these claims would have made a difference. And the standard is cumulative errors. It's not just one error, it's cumulative. All of these errors, all of the jury find.
This circuit has never said that that's the standard, cumulative errors.
That it's not,
That cumulative errors, I mean, is there a case that says that's the standard?
for prejudice.
Yeah.
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 I apologize if I argued that and they didn't dispute it, but if I have the standard wrong, I apologize.
Okay, are there any further questions from my colleagues?
I'm done.
Thank you. Case is submitted.
Case number 23-5067, Medical Imaging and Technology Alliance and Advanced Medical Technology Association Appellants versus Library of Congress and Carla Hayden in her official capacity as Librarian of Congress. Mr. Kimberly for the appellants, Ms. Myron for the appellees. Good morning.
Morning, Your Honors. May it please the court. My name is Michael Kimberly, and I represent the appellants. Your Honors, if I may, I'd like to start where I think there's common ground among the parties and the district court. And that's that when the Library of Congress uses APA notice and comment rulemaking procedures to promulgate a regulation that's published in the Federal Register, codified in the Code of Federal Regulations, and implements a statute that settles the rights of regulated parties with the force and effect of law, it's acting as a component of the executive branch and not the legislative branch.
Okay, but let's talk about that because that's somewhat of a hybrid argument that when an agency has certain functions that are executive and then certain functions that are legislative, somehow that we allow the APA to separate that out and then allow there to be APA review as opposed to looking at categorically what the agency is or the entity is.
Your Honor, what this court's cases teach on that front, and I think Washington Legal Foundation is a good starting point, Pickus and Ryan are other examples, is that in determining whether a government entity is an agency for APA purposes, what the court is to look at is the branch of government in which that entity is located. So
They're located in Congress here.
no, that's the thrust of our point, Your Honor, is after intercollegiate, there can be no question that in this respect, the library really is a unique agency with feet in both branches of government. It is unquestionably exercising executive authority. This is the quintessence of the execution of laws to promulgate regulations that implement them. It can't be a part of the legislative branch in undertaking that function. If it were, we'd have a very serious
That's what I'm
separation.
getting at. Can you separate or segregate the functions to then determine based on what function that they are performing at that particular time, that then determines whether or not you come under APA review?
And so I would say, Your Honor, with respect to agencies that are categorically within the executive branch, the answer is no. I think the question with respect to the library is somewhat different. You have to ask what role, sort of what hat, if you will, it's wearing at a given time. It has a legislative branch hat and it has an executive branch hat. It's unique, I think, among agencies, certainly among agencies that this court has considered in any of its prior APA cases.
But have we
in that
ever
respect.
found that you can, again, segregate these roles and then determine when it's exercising a particular role? For example, in the executive branch, that's when it then comes under APA review, when otherwise it also has legislative functions.
Your Honor, I think the relevance of the function that the library is playing is not direct relevance, but rather relevance insofar as it indicates the branch within which the library is with respect to the action that it's undertaking. So, and I would add that the idea that the APA's definition of agency allows for consideration of function is baked into the definition of itself. 5 USC section 701 specifies, for example, that even with respect to purely executive government entities, any that, quote, functions conferred by section 1738 and so forth are to be excluded from the APA. Those functions relate to things like mortgage insurance. So the APA itself accounts for the idea that sometimes function is taken into account. The distinction between Congress and the courts and the executive itself embodies an understanding that function is relevant to determining whether a government entity is an agency or not.
Do you have other examples of other agencies treated that way, where their functions changed?
No, Your Honor, because as I said, I think the library is in this respect unique. We're not aware of any other agency that has been characterized by this court in binding precedent and other courts as a hybrid entity that at times functions as a part of the legislature and at times functions as part of the executive. This court has dealt.
Kimberly, then why did you not raise your separation of powers claims on appeal? Because they were raised below and decided by the district court, and then they were not. So I'm curious about that.
Your Honor, it's because we take intercollegiate at face value, and we understand the government in this case to acknowledge and agree that the library is in fact a component of the executive branch.
So what would be the consequences if this court were to hold that the library is an agency for purposes of the APA? Then would all of the library's congressional type functions also be subject to APA review?
I don't think the court has to say that, Your Honor. I think it's enough to say that for purposes of resolving this appeal, that when the library is engaged in traditional APA notice and comment rulemaking, again, quintessential executive exercise of executive power, that in that role, it is an agency for purposes of the APA.
And so then how would we decide which of its functions in future cases were executive and which were legislative?
Well, Your Honor, I think the Fourth Circuit's decision in Eltra Corporation gives a roadmap for understanding how that might work. I'd say I think probably what you're looking at really is just whether the library is engaged in rulemaking. We've not been able to conceive any other circumstance in which the library is exercising purely executive power.
There's lots of statutory rulemaking authorities, some of which just involve internal matters or matters that perhaps relate to its function as some kind of support entity of Congress. Would those actions all become APA reviewable?
Your Honor, I don't think so.
You don't think so, but once we've said it's an agency, then what's the consequence?
Well, but again, I don't think the court has to say it's an agency for all and every purpose or all purposes. I think it's enough to say when it is engaged in APA rulemakings, it's plainly an agency.
Was that circular APA rulemaking? I mean, what about the other rulemakings?
Well, I would say about the other rulemakings, Your Honor, first of all, those are not undertaken according to notice and comments. There's not publication in the Federal Register, which is another indication that Congress understood that the library is an agency for this purpose. The Congress itself will issue rules and regulations for, say, conduct within the Capitol complex. That is not, an exercise of executive authority, and we wouldn't say that it is with respect necessarily to the library either. There's nothing inherent in that sort of self-governance and administration that's inherently executive or implementing law the way that a regulation that settles the rights of private regulated parties does.
But what about when we've come out right and said the Library of Congress is not an agency as defined under the Administrative Procedure Act?
This court has said that at least 3 times. We're supposed to look at what our colleagues have said in sittings before our sittings. We've said it definitively, clearly, and explained it enough so that I wasn't confused about what my colleagues in the past thought. In fact, I was on one of the cases. We have held against you. With the precise point that you have now advanced in this court has been rejected at least 3 times by this court.
Your Honor, I absolutely must disagree, respectfully. Clark is the starting point, a case from 1984 that predates the DMCA, which gave the library this executive rulemaking power. That case has to be viewed just like ethnic employees has to be viewed through the facts of the case. And the facts of that case were an employment dispute concerning a First Amendment retaliation claim, did not implicate the library's executive function in any way, shape, or form. And this court was not presented with the question whether the library, when it is wearing its executive hat, when it is functioning as, in the words of Intercollegiate, a component of the executive branch, it must be understood as an agency. I would say, and ethnic employees involves the same basic fact pattern. It's an employment dispute. None of the other cases where Clark is cited for this proposition turns on this proposition at all. So I think it would be respectfully incorrect to say that any of the other cases hold it.
We must be reading different cases. There are 2 other cases in addition to one you've mentioned in which the court has clearly said that the Library of Congress is not an agency under the APA. And it is said in such a way that I was not confused. It would not matter about functional. No one has accepted this functional analysis that you're offering us now. And we have said consistently, and I say to myself, why would I walk away from my colleagues who said in the past? It is not an agency under the APA, period.
Your Honor, there are 2 responses to that, if I may. The first response is this question just wasn't posed in those other cases. The DMCA was enacted. The DMCA, which accords the librarian executive rulemaking power, was not enacted until after Clark was decided. So it just wasn't
Not just Clark. There are cases after Clark.
Dealing with the same basic fact pattern as Clark. And Your Honor, what I would say beyond that
And
is—
none of them limited themselves that way. They took the legal question that you're now posing and they gave an answer that's inconsistent with the one that you're offering. They rejected it.
Your Honor, the question whether the library was for any one purpose or another an element of the executive branch that constitutes an agency just wasn't presented in those cases. It's not surprising that the court wouldn't acknowledge a limit that wasn't brought to its attention at the time and wasn't relevant to the outcome of the case. I would add additionally, Your Honor, that we have here the canon in favor of judicial review and the notion that, the government's position in this case is that the word Congress appearing in Section 701 has to be understood to include an agency that functions as a component of the executive branch. We don't think that's a plausible way to read the statute at all, but if it were, it certainly isn't the only permissible reading of the statute. And therefore, it's one that this court needs to resolve under the canon in favor of judicial review in favor of the person.
Mr. Kimberly, so it seems to me, when the APA was enacted in the 40s, the Library of Congress did not have any executive functions or executive powers that were assigned to it. And our cases recognize that, broadly speaking, in some kind of historical sense, the Library of Congress is part of the Congress or some kind of auxiliary to Congress. And then it seems to me, as you've suggested, the library has been given rulemaking authority and given executive powers by Congress in the Copyright Act and the DMCA. And so I think you have to have an account of which one of these things trumps, right? Is it the fact that they now have executive power and so therefore are an agency within the meaning of the EPA, or do we still understand it as somehow part of the Congress, which is exempted from the APA? And I think those two things are in tension, in part because of subsequent statutes and subsequent powers that have been assigned to the library.
And Your Honor, if you're inclined to look at it in that categorical way, that it's got to be one or the other, I think after enactment of the DMCA and after this court's opinion in intercollegiate, there can be no question but that it is a component of the executive branch and not the legislative branch.
Well, but it could be a component of the executive branch and then possibly still exempted from the definition of agency because it's part of the Congress.
And I think, Your Honor,
because there are other exemptions, there are other entities that exercise executive power that are also exempted from APA review. So I think you have to have some account of why the library has sort of fallen out of that congressional exemption category.
And the answer simply is the allocation to it of executive rulemaking power. Congress is even so, take as given for purposes of this argument that prior to the assignment to the library of executive rulemaking functions, it was a part of the Congress.
Yeah, I think just assume that.
Yeah,
for purposes of
just assume for the sake of argument.
Right.
Congress can convert the library into a executive agency by allocating to it powers that cannot be exercised by an element of the Congress and must be exercised only by elements of the executive branch. I would add we have other textual clues here that Congress would not have intended to exclude the library from judicial review in circumstances like this. The librarian herself is appointed by and removable by the president, suggesting that control over this agency is within the executive branch. And again, it's utilization of the Code of Federal Regulations and the Federal Register, which are two things that Congress has said very expressly are things that only executive agencies within the executive branch are empowered to do. There's no question the library is engaging in that kind of traditional notice and comment rulemaking using the Federal Register and the Code of Federal Regulations. There's a strong presumption in favor of judicial review of actions like that. And even if it's conceivable that the word Congress could be read by this court to cover the library, it's certainly true that it also can be read not to cover the library. And under the canon favoring judicial review, that is the interpretation the court is duty-bound to adopt.
And so do you think we should read the Copyright Act and the DMCA as making those regulations APA reviewable? And do you think that's clear?
I think it is clear, Your Honor, that
Because the DMCA doesn't say anything about APA review, unlike the Copyright Act.
No, it doesn't. But what it does is clearly assign to the librarian purely quintessentially executive rulemaking functions, which are presumptively subject to the APA. There's, I submit no reason to think that in assigning to the library tasks that only agencies can do, such as notice and comment rulemaking using the Federal Register, culminating in the publication of the codification of a rule in the Code of Federal Regulations, that the Congress would have had anything else in mind. And again, that's why this court has a clear statement rule for statutes that deny judicial review of agency action. There would have to be a clear statement in the DMCA or elsewhere that Congress didn't want this sort of rulemaking reviewed. And we know that Congress knows how to do that. For example, it exempts the Postal Service from judicial review under the APA using clear, plain language to that effect. There's no such language here with respect to the library. We know after intercollegiate that it is a component of the executive branch that is presumptively subject to judicial review.
But at least here we have the US copyright laws that make the Copyright Office a subsidiary of the Library of Congress, and that's subject to the APA. And, you know, coming up as a subset of the Library of Congress, so would it not be almost duplicative, you know, to allow the Library of Congress to also be subject to APA review when we would already have that situation covered here?
Your Honor, I don't think so. In part because we don't understand at the time that Section 701E was adopted that the librarian was exercising purely executive rulemaking powers the way that it does today. 701E was part of a broader sort of cleanup statute for the administration of copyright laws in the Library of Congress as a whole. It's what established statutorily the Copyright Office to begin with. But 701E, more importantly, says that all actions of the Copyright Office are subject to judicial review. Our position is that the library is a hybrid. There are some roles in which, as this court said in intercollegiate, there are some roles in which it's best understood as a congressional agency, some in which it's understood as an executive agency. Our position is when it is acting as an executive agency, engaging in that notice and comment rulemaking, that then it is subject to judicial review, which is not necessarily covered by 701E.
And you kind of suggest, I'm sorry, that the library is required to publish in the Federal Register, but that's not really true, is it?
No,
No, I misspoke if I said it's required to publish in the Federal Register. It does publish in the Federal Register. It has all along. We're into the 8th triennial rulemaking. Every single time it has published notices of inquiry, notices of proposed rulemakings, and final rules in the Federal Register. This is a clear indication that every other element of the executive branch understands the library to be an executive agency for purposes of the Federal Register Act, which bears the same substantive meaning of the term agency as does the APA, as this court held in Washington Legal Foundation.
Mr. Kimberly, is it your view after intercollegiate that once this court said that the library is a department, you know, and that the librarian is the head of a department within the executive branch, then by definition, the library cannot be part of the Congress within the meaning of the APA?
Within the meaning of the APA, yes, Your Honor, at least with respect to, well, maybe the way to think about it is that it's always an agency, but when it's, you know, when it's serving those legislative functions, perhaps bear some different characteristic that make it non-reviewable under the APA. I think
Does that mean that are those areas in which its actions may be non-reviewable? Are they non-reviewable because they're legislative or simply because they're actions that would, you know, even if they were undertaken, you know, by the Department of Agriculture would be non-reviewable because they're just not reviewable agency actions?
Right, because they aren't final actions that sort of set the rights of parties in a legally enforceable way. I think that's probably the way to think about it. It's if you're inclined to think about the library as either in the executive branch or in the legislative branch, and therefore either as an agency or not, I think that's the way to think about it. And there's still reason to think those sorts of actions would not.
I'm not sure that we're allowed to think of something as being a hybrid entity. I mean, the Constitution has 3 separate branches. So I mean, I'm not even sure that we can't, I mean, do you think it's within the bounds of the Constitution to think about some entity as being both part of the legislative branch and part of the executive branch?
You know, Your Honor, I don't think it is squarely foreclosed. I think about the vice president, for example, obviously an official within the executive branch.
That's within the Constitution. The vice president wears 2 hats.
It is, and I don't want to argue against myself here because I think if the library is one thing or the other, after the DMCA and this court's decision in intercollegiate, as I say, it's got to be an executive branch. I guess where I'm going is I'm not sure the court has to go that far in this case. We're happy for the court to take that approach if that's what it prefers.
It's interesting. I mean, the Supreme Court, you know, used to say that the independent agencies were, you know, quasi-judicial or quasi-legislative. And there are 9 justices on the Supreme Court all agree now that independent agencies are within the executive branch. I wonder if there's some analogy with the Library of Congress.
There may be, Your Honor. We take our clue from Intercollegiate, which describes the library in some circumstances as a quote unquote congressional agency. If the court feels that the next step is the appropriate one in acknowledging that the library is a component of the executive branch in all circumstances, again, that's just a different road to the same outcome, which is at bottom, this is textbook, like perfect example, executive agency rulemaking that the Congress responsible for the APA, of course, would have understood to be subject to judicial review under the APA's judicial review provision.
And just so that I'm clear, because we have talked about cases in which this court has already decided that the Library of Congress is not an agency, what is your opinion about how we deal with what is already precedent in this court?
So I think you can look at cases that predate the DMCA, and I believe that includes, I'm sorry, I'm forgetting the publication date of ethnic employers, but it certainly includes Clark. I believe it also includes ethnic employers, which was a 1990s decision. And say simply that the DMCA is an intervening development that, as the court recognized in Intercollegiate, sort of changes the character of the library and allows this court to recognize that Clark has since been abrogated. That would be an outcome we'd be happy to have the court reach. We think it would be appropriate and consistent with the principles that we've briefed.
So you're offering to write the order?
I'm sorry?
You're offering to write the order?
Sure, if you'd like. In all events, whether it's a more modest approach that recognizes consistent with Intercollegiate, with some of the language suggestive in Intercollegiate that it's really got feet in 2 branches, or instead only 1, either way, I think Clark doesn't control this case because it involved different facts. It did not involve the library acting as a component of the executive branch. And so these issues just weren't before the court in that case, or in ethnic employees. And that the DMCA and Intercollegiate are intervening developments that abrogate that line of precedent. Thank you, Your Honor.
Yeah, thank you, Mr. Kimberly.
Good morning. May it please the court, Laura Myron for the government. There are 2 basic propositions that resolve this case. First is that an entity either is or isn't an agency for purposes of the APA. And the second is that this court held 40 years ago in Clark that the Library of Congress is. The APA provides a textual definition of an agency that makes fairly clear that it's an entity by entity analysis. It doesn't speak to what particular function the entity is carrying out in any given case. That definition has to mean something, and it means the same thing without regard to the claim before.
Ms. Myron, don't you, what is the government's position? It seems now, after the Copyright Act and the DMCA, that the library meets the definition of agency as exercising authority of the government of the United States.
I guess
Do you dispute that proposition, that it meets that definition? I mean, before we get to whether it's within one of the exemptions, doesn't the Library of Congress now meet the primary definition of what an agency is?
Well, I guess I'm not sure why if you think the question is whether, does the entity, is it an authority of the government of the United States? It has always been an authority of the government of the United States. And
I'm not sure that's true. I mean, our cases describe authority of the United States as being, basically an executive entity. I mean, if you look at cases like Dong versus Smithsonian and Meyer versus Bush, right? Authority of the United States means exercising executive power, issuing final and binding rules that affect private parties. So the Library of Congress didn't meet the definition, the primary definition of agency when the APA was enacted.
Well, I disagree with that, Your Honor, and I think 701 of the Copyright Act is particularly good textual evidence of that. I mean, the Copyright Office was engaging in a number of functions that I think plaintiff would describe to you as executive functions prior to the 1976 Copyright Act. In fact, there was a hearing before the relevant committee in which the question was raised about the fact that the APA did not apply to the Copyright Office. And Congress responded to that by enacting 701, which says that all actions of the Copyright Office shall be subject to the APA. It did not say that the Library of Congress shall be an agency for purposes of the APA. I think 701 also suggests that first, Congress didn't view it as an agency, and second, that it knows how to subject something to the APA expressly when it chooses
So
to
I'm
do
glad you
so.
brought up 701 because 701, the Copyright Office has rulemaking authority and the actions of the Register of Copyright are subject to APA review. However, the rulemakings by the Register are all subject to the approval of the librarian. So doesn't that mean that under the copyright, the librarian's approvals of copyright regulations are subject to APA review?
Well, no, Your Honor. The establishment of the regulations are subject to APA review because that's an action of the Register.
But the regulations can't become final until they've been approved by the Register.
Well, there hasn't been any claim in this case that, there's, should be an APA challenge to the approval of a Copyright Office regulation. And
But if we to say that the library wasn't an agency, and I mean, I don't know what that would mean actually for reviewability of regulations that require the approval of the librarian.
Well, respectfully, Your Honor, this court has already said that the Library of Congress is not an agency. It said so several times, all of which postdate the enactment of Section 701 of the Copyright Act, and in fact rely in part on that particular provision as textual evidence that the Library of Congress is not itself an agency subject to the APA.
So the Copyright Act says that these copyright regulations are subject to APA review. And those regulations need the approval of the librarian. And then Congress comes along with this kind of smaller Copyright Act, the DMCA, which gives the librarian direct rulemaking authority. I mean, isn't there some maybe natural assumption that Congress wants those regulations, those copyright regulations, to also be reviewable under the APA?
Well, no, Your Honor, I don't think you can reverse engineer the definition of an agency based on the use of the term rulemaking in the DMCA. I mean, if Congress had said, and these rulemakings shall not be subject to the APA, there's no reason to think there would be any problem with that. And
they could have said that, but they didn't. And they had already created a general structure where copyright regulations were reviewable, even regulations that require the approval of the librarian. So they're not just promulgated by the Register of Copyrights. They are put into effect after the approval of the librarian.
Well, there's certainly no question here, and perhaps I'm misunderstanding, but there's certainly no question that the rulemaking at issue here should be subject to APA review because it's an action of the Copyright Office. The statute makes very clear that the Copyright Office submits a recommendation to the librarian who makes the final determination.
That's not exactly my argument. My argument is that there are a series of statutes here. We have the APA in the 1940s, we have the Copyright Act, we have the DMCA, and then there's a question about under the DMCA, should the regulations issued by the librarian be reviewable, under the APA? And maybe one way of reading all of these statutes together, the best reading of reading them all together, is that the librarian's copyright regulations are reviewable under the APA.
So I think your argument, Your Honor, is a suggestion that an entity—
Or you can tell me why that's—
sometimes is an entity, that the library, sometimes may be an entity for purposes of the APA and sometimes isn't. Because certainly I don't take that to sweep into it all of the things that we've discussed in our brief that the Library of Congress does that wouldn't be subject to the APA. And that argument simply is irreconcilable with the text of the APA, which defines an agency as an entity, and also with the way that this court has understood that question in cases like Washington Legal Foundation and Pickus and Ryan, in which the court has said that the question of whether something is or isn't an agency for purposes of APA review is an entity by entity.
What I'm suggesting is maybe this court doesn't need to reach the question of whether it's an agency under the APA, but could reach the question of whether these types of regulations under the DMCA are reviewable under the APA. Because there are things that are subject to APA review in entities that may not otherwise be agencies.
Respectfully, Your Honor, I just don't see how you get there, given this court's cases in Clark, which say that the Library of Congress is not an agency, and the particular text of the APA, which provides for judicial review of agency action. It doesn't sort of say wherever there's rulemaking that shall be subject to APA review. It says there shall be review of final agency action.
I think maybe you're not responding to my question, which is that Congress has said the copyright regulations are subject to APA review. Whether or not the library is an agency, they've said that these rulemakings are subject to APA review.
So perhaps,
And so you're saying that like why shouldn't we read the DMCA to kind of include that sort of APA review of copyright regulations? Because this is effectively a copyright regulation.
no, respectfully, Your Honor, the text of the statute is very clear that it is not a copyright regulation, that it is a determination by the Librarian of Congress. And that is an important difference because the librarian makes that determination on recommendation of the Copyright Office as provided by the statute. But I don't think it's fair to read the rulemaking at issue here as a regulation of the Copyright Office. We're certainly not contesting that regulations of the Copyright Office issued by the Register of Copyrights, established by the Register of Copyrights, are subject to APA review. That's provided for in 701. But I don't think you can make this sort of additional jump to think that this is a rulemaking, this is a regulation of the Copyright Office, because the statute very clearly vests the determination with the Librarian of Congress. And as this court has said for nearly 40 years, the Librarian of Congress is not, and the Library of Congress is not an agency subject to the APA. Congress has never disturbed that. Section 701 provides additional textual evidence to support the conclusion that Congress used the actions of the Copyright Office as separate from the actions of the librarian and subject to APA review. And so I just don't see how you get to a conclusion that these particular regulations or rulemakings are subject to APA review, is particularly where the APA does not contemplate that entities will sometimes be an agency for purposes of the statute and sometimes not be an agency.
And I want to get back to that the Copyright Office is actually just making a recommendation. It's not final.
Yes, Your Honor. In this, the text of the DMCA is very clear that the Copyright Office submits a recommendation with consultation with some other parts of the Department of Commerce, and that the librarian makes the determination independent of the recommendation, or considering the recommendation, but sort of not as part of the Copyright Office's actions here.
And does it matter in this analysis on agency that the library gets its appropriations from the legislative branch?
It's certainly relevant, Your Honor. I mean, that is an argument that was put before the court in Clark and cases like that, and supports the court's conclusion that the library is not an agency for purposes of the statute. The question whether something is part of the executive branch or the legislative branch for constitutional purposes is separate from the question of whether it's part of the Congress for purposes of the statutory provisions in the APA. And so other statutory provisions like the legislative appropriation, like Title II, are particularly relevant to the statutory analysis, and I think inform the court's decision in Clark and the subsequent cases that the library
I'm sorry. Go ahead.
is not an agency.
Does the librarian have authority to make the determination that's in dispute here without a recommendation from the Copyright Office? Both the facts are they never came. Can the librarian just act?
The statute provides that the librarian shall make the determination upon recommendation of the Register of Copyrights. It doesn't say anything about whether the librarian must adopt the recommendation or can disagree with it. And certainly the librarian is free to disagree with the recommendation if she does not agree with what's been recommended by the Copyright Office. And I think that supports what I think Your Honor is getting at, that the determination is very clearly by statute vested with the librarian and not with the Register.
You've suggested that, Congress, the question is what Congress has done with respect to, how it views the Library of Congress. I mean, one way to think about this is that, when the APA was enacted, the library was some kind of support entity for Congress. And now Congress has actually given the library fairly substantial executive powers. And maybe by statute, then, Congress has over time taken it out of the Congress for purposes of the APA.
I don't think so, Your Honor. I mean, certainly that seems like an argument that Clark is wrong because the Copyright Act itself predates Clark.
Yeah, but Clark wasn't dealing with any of these issues. I mean, it wasn't, it's not a there's not well-developed reasoning. And even our subsequent cases like Washington Legal Fund suggest that maybe Clark was mistaken, talking about the judiciary. Ultimately in Washington Legal Fund, we relied, the circuit relied on a statute, the SRA, in making its determination. It didn't rely on Clark and its reasoning. So.
Well, I guess I would also point you to Section 701 of the Copyright Act, which shows that even when Congress was enacting the Copyright Act, it recognized that the library was not an agency for purposes of the APA and gave APA review. It included the Copyright Office itself as part of
So you could view
the
it
APA
as maybe being superfluous, or you could just view it as kind of belt and suspenders. Like, of course, we're giving them this kind of important rulemaking authority that affects private rights and obligations. And so we're going to be very clear that that's going to be subject to the APA.
But respectfully, Your Honor, the statutory interpretation principles of this court and the Supreme Court are that we don't interpret provisions like that to be purely superfluous. And there doesn't seem to be a reason to think that Congress would do that. And, prior to the enactment of the.
Whether it's superfluous, but I mean, I think, you're reading it to be that there's a negative implication that otherwise the APA would not have applied to the Copyright Office. And I'm not sure that the negative implication is the only way to read Section 701.
Well, respectfully, Your Honor, that's how this court has understood the application of the APA, that the Library of Congress is not an agency for purposes of the APA.
Not since intercollegiate.
I don't think intercollegiate changes the analysis in any meaningful respect, because the question before the court in that case was whether the Library of Congress is an executive department for purposes of the Appointments Clause, for purposes of the Constitution. The Supreme Court in cases like Browne has recognized that an entity's constitutional status is a separate question from its statutory status. And in fact, part of the argument in that case was that the Library of Congress is for statutory purposes funded through Title II, that it receives its appropriation through the legislative appropriation, that it's not subject to the APA and FOIA. And what the court said was that for purposes of the Appointments Clause, that it is an executive department, and it looked to the fact that the Librarian of Congress had been appointed by the president dating back to the 1870s. The appointment by the president is not a new change in the law since Clark and those cases have been decided. And there's no question that executive departments or parts of the executive branch might be exempt from the APA in the definition of agency, or otherwise not subject to APA review. And so I just don't see how that gets you to.
I mean, I think that's true that the constitutional and statutory meanings are distinct. But once this court has said that the library is a department within the executive branch, how can it, for statutory purposes, be part of the Congress APA?
Again, I don't think that the question of whether it's a constitutional part of the executive branch reflects on how Congress decided to treat it as part of the statutory definition of an agency within the APA. And certainly that argument would require this court to consider cases like Clark and ethnic employees and Washington Legal Foundation to be wrongly decided, which I don't think is an argument this court can entertain in this particular question.
Colleagues have any further questions?
Thanks.
Okay. Yes, thank you.
Thank you.
Mr. Kimberly, we'll give you 2 more minutes.
Thank you very much, Your Honor. I think as the case is now presented to the court, it really involves 2 questions. The first is whether the outcome here is controlled by precedent. And the second is, if it isn't controlled by precedent, is the library an agency within the meaning of 701(b)(2). On the first question, just 2 cases have actually held that the library isn't an agency. Those are Clark and ethnic employees. Clark was decided in 1984. Ethnic employees was decided in 1985. Washington Legal Foundation was a case about the Sentencing Commission, not about the library. What it had to say about the library was dictum, but in any event, it was decided in 1994. All three of those cases predate the Digital Millennium Copyright Act. All three cases predate this court's decision in intercollegiate. And I think it's easy enough to say that those cases therefore have been abrogated as recognized by implication in intercollegiate. So that leads to the second question. If it isn't controlled by precedent, what's the right outcome? And on that score, the answer depends on whether the library, for purposes of this case in particular, or more generally as a categorical matter, is a component of the executive branch. If it is a component of the executive branch, then the outcome must be that its executive rulemakings are subject to judicial review, because to say otherwise puts the government in the very uncomfortable position of saying that when Congress used the word Congress, it meant to include components of the executive branch exercising executive power. Now, whatever you might say about that position, it surely is not compelled by the statutory text. And because we have the presumption in favor of judicial review at play in this case, that means the court has to consider our position and whether it is an alternative reasonable position that better accords with the presumption that agency rulemakings are subject to review in Article 3 courts. Our position is at least reasonable, that when Congress said Congress, it didn't mean to include agencies like the library exercising executive power, undertaking executive rulemakings that is confirmed further by the Federal Register Act, under which the library is, by definition of that act, an agency because it uses the Federal Register and the Code of Federal Regulations, all pointing, in our view, to the clear text conclusion that the library is an agency, and at the very least to the conclusion that the presumption in favor of judicial review requires reversal. That was submitted. Thank you.
Thank you, Mr. Kimberly. The case is submitted.
Case number 23-7077, Valores Mundiales S.L. and Consorcio Andino S.L. versus Bolivarian Republic of Venezuela, Ministerio del Poder Popular para Relaciones Exteriores. Mr. Perla for the appellant, Mr. Lopez Forestier for the appellate.
Morning.
Good morning. Juan Perla for the Bolivarian Republic of Venezuela. I've reserved 3 minutes for rebuttal. May it please the court. The primary question in this appeal is whether, as a matter of U.S. law, federal court may enforce and give full faith and credit to an ICSID award that was rendered in proceedings where the only U.S.
Can you lift that lectern up some?
Yeah, thank you.
I can't hear you.
Well,
Question is whether an ICSID award that was rendered in proceedings where the only U.S. recognized government, foreign state respondent, was not allowed to defend the state, and instead an unrecognized, illegitimate government was purportedly allowed to talk and speak and bind the foreign state in those proceedings. The answer is no, because the statute that implements the ICSID Convention commands so. And we begin with the statute. We begin with the statute because the ICSID Convention, under the ICSID Convention, ICSID awards are not self-executing. So they are only enforceable to the extent that Congress required them to be. And the text of the statute is clear that you have to treat and enforce and give the same full faith and credit to an ICSID award as if the award were a judgment of a state court. And that is critically a critical part of the text of the statute, as if the award were. That means that you can't look at the ICSID award, like the district court did, and say, this has to be enforced because it's special, it's different, it's ICSID. That cannot be that cannot be the basis upon which the analysis turns, because the question is, if the award were a state court judgment, how would I enforce and give it full faith and credit? The Second Circuit in the Mobile case has already adopted and ruled that you have to assimilate ICSID awards and enforce them as if they were state court judgments. Several district courts in this circuit have followed the same approach and said that you have to treat them in a parallel manner. That interpretation is consistent with the ICSID Convention. The United States drafted a specific provision for itself in Article 54.1. And textually, that provision applies to a contracting state with a federal constitution. What more obvious way for the United States to make its federalism and constitutional concerns understood and adopted into the convention than using that language and insisting on including that language in Article 54.1 for purposes of enforcement within the United States. And when you treat an ICSID award as if it were a state court judgment, you have to apply the same procedures and substantive standards. That means you have to bring a plenary action, give full notice of the proceedings to the foreign state, assure yourself of personal and subject matter jurisdiction, validate the authenticity of the award, but then you also have to undertake the ordinary analysis that a federal court would do for whether you can enforce and give full faith and credit to that award as if it were a state court judgment. And there are grounds for refusing to enforce and give full faith and credit to a state court judgment, as limited and rare as they may be. And there is no dispute that those exceptions exist. And in this case, the problem with enforcing this ICSID award is that if a state court judgment were rendered and the US recognized government was not permitted to defend the state, and instead an unrecognized illegitimate regime were allowed to come in and purportedly speak.
Well, this wasn't a state court proceeding, it was an ICSID proceeding. And within the rules of ICSID, there was no problem with the representation.
Again, Your Honor,
And then-
once you bring that award to the United States, you have to treat it as if it had been rendered by a state court.
But that doesn't require de novo review.
No, Your Honor, it doesn't require de novo review, but that is not what Venezuela is arguing here. We're not saying that there has to be a review of what the ICSID annulment committee did. What the court here has to do is undertake its own independent analysis under the US implementing statute as to whether this award, if it were a state court judgment, could be enforced and given the same full faith and credit. I'd like to point you to the annulment committee's
So you're
decision.
saying we have to undertake a merits analysis?
An independent analysis under the US implementing statute as to whether this award, if it were a state court judgment, could be enforced and given the same full faith and credit. That is different
So
from
when
what
we
the
do that,
ICSID.
we look to whether it would be valid within the state court. And here we look to whether it was, due process within the meaning of an ICSID
ICSID, right.
proceeding. And so we look to that. It's the ICSID standards are not the same as what would be required in a state court.
Well, Your Honor, a couple points on that. First of all, the ICSID annulment committee itself at Joint Appendix 512 understood its own task, not as making a determination for all purposes. It says, there is no doubt that the committee cannot decide with effect erga omnes, which is Venezuela's legitimate representative. Erga omnes is an international obligation that is binding on all for all purposes. So even the ICSID annulment committee understood that it was making a very narrow determination. If this court were obligated by the ICSID convention to give effect to that recognition of the Maduro regime, it would effectively put ICSID above the Supreme Court, above the executive branch. It would basically take an international decision and make it a part of the US legal system where a state court decision in the same
They weren't
circumstances
giving
would not.
recognition to a particular government. They made that clear.
The ICSID annulment committee
Yeah.
was recognizing only the Maduro regime and deciding that the interim.
They were issuing against the Venezuelan state. They weren't making a determination as to who should be recognized. So whatever your argument might be, if it were in a state proceeding, and I understand what you're saying, it's not what they were purporting to do. And it was a very fair procedure, at least facially. Everyone was given an opportunity to present on the issue, whether the state was adequately represented, and they explained why they did what they did. And that seems to me would satisfy due process requirements as we're supposed to enforce them in this kind of a situation. It's not the way we look at what goes before a state. We have to look at what the ICSID procedure was and whether it satisfies due process requirements. They did what they were supposed to do.
I had reserved 3 minutes, so if I could respond to that. What ICSID did as a matter of ICSID is not what we're challenging. Valores can take this award under the ICSID Convention to another contracting state that recognizes the Maduro regime, and it may be enforceable there. But once you bring that award to the United States, you cannot import a recognition of the interim government and give it legal effect in contravention of and in defiance of the executive branch's recognition that only the interim government is Venezuela. And that comes directly from Zivotofsky. Zivotofsky says that the US executive determination of a government is a determination as to who is Venezuela, who is the effective government of Venezuela.
Mr. Carlo, here in this court, are you representing the Maduro regime of Venezuela or the interim government of Venezuela?
We represent.
Who is your client?
Yeah.
Our client is Venezuela's in the interim government. That is who we represent and we take instructions from. So the interim government, and this is important, and actually this is critical because right now, Valores is not in the US just, to get an award or to get a judgment and that's all the end of it. We're on an expedited procedure here because Valores is rushing to get to Delaware, where they claim they can attach property of Venezuela. That is, in which, as a matter of US law, the Maduro regime has no cognizable interest. They chose to litigate only with the Maduro regime at ICSID, but they're coming now to the United States, in contravention of the recognition doctrine. But now they're coming to the United States and trying to attach property that they claim belongs to Venezuela, which the United States executive has said only the interim government has any interest in terms of the representation of the government. This is a problem because what Valores is trying to do here is to take this award and give it effect under US law. But under US law, the Maduro regime does not represent Venezuela. The Maduro regime is not Venezuela. Only the interim government
US law, you can't really collaterally challenge an ICSID arbitration. I mean, the
Right.
Federal Arbitration Act doesn't apply. I mean, it's very limited grounds for challenging ICSID, and that's by the convention and by the implementing statute.
And we are here under the implementing statute. And the implementing statute is what requires this court to give no greater deference to an ICSID award than it would to a state court judgment. And again, the analysis cannot turn on how ICSID is special, not for enforcement purposes. The analysis has to turn on what would happen if this were a state court judgment. I'll point to the Pink decision in the Supreme Court. There's two Pinks, but this is Pink v. AAA Highway Express. And in that case, the New York courts rendered a judgment against a mutual insurance company, including members who were Georgia citizens. But the Georgia citizens did not appear in New York. And when they went to Georgia to enforce the award, the Georgia court said no, because as a matter of our law, these Georgia citizens never became members of that mutual insurance company. Therefore, they're not bound by that judgment. And that decision, under full faith and credit, went up to the US Supreme Court. And while the judgment against the mutual insurance company may still be valid and enforceable in New York, as a matter of constitutional full faith and credit, Georgia did not have to give full faith and credit and enforce that judgment against its own citizens in Georgia. It undertook that analysis for itself, and the Supreme Court upheld it.
But it didn't involve ICSID.
But it doesn't matter, again, because under the
Not-
ICSID implementing
it just
statute,
doesn't-
but under the ICSID implementing statute,
Points don't lead to the conclusion. I mean, I may be missing something. I don't see how you get to the conclusion you're advancing in that case.
because textually,
Where you really want full substantive review. what do we think about this? That's not what the law requires us. Not the convention, not the implementing statute, not any of the case law. That's not what we're supposed to do. We're to determine whether ICSID followed the rules of due process, reasoned decision, honest, nothing untoward in the normal sense, and that's that.
Your Honor, respectfully, the ICSID implementing statute does require something more, and that is what controls
This
in the
can't
US.
be, in other words, you keep saying like a state as if this proceeding would have been in a state. It wouldn't have been in a state. The only place this would have occurred was where it initially occurred, in that arbitration. So that's what we look at to see whether due process was followed. So it's fanciful to say, well, think about how a state would have litigated this. No, that's not where it would have been litigated. It would have been litigated exactly where it was. And the question is whether due process was adhered to.
Your Honor, but the ICSID implementing statute, Congress directed the court to engage in what you call this fanciful analysis by saying, treat it as if the award were.
That's what the convention says too.
Yes, and that is what.
But it doesn't have the meaning that you're suggesting. It doesn't make it other than the procedure that it was. And indeed, Congress was giving recognition to that procedure by adopting the convention and saying, that's okay under our law, just make sure due process is followed because that's what we require of the states. We don't second guess the substantive decisions.
There isn't a second guessing here of the substantive decision because this court cannot say that the Maduro regime and cannot give effect to what the ICSID annulment committee said the Maduro regime represents. They are not Venezuela. Venezuela was not defended and represented as a matter of US law at the stages of the annulment proceedings. And that is what makes all the difference. Once you bring the ICSID award into the US legal system and you try to use that judgment then to go after property of Venezuela, reportedly property of Venezuela, in which the Maduro regime has no cognizable interest. It basically is like in Civitowski. It's not just about which lawyers come and represent Venezuela in the US courts. It's about whether you can put the name Israel on the US passport of a person that is born in Jerusalem. If Congress can't tell the executive to do that, how can ICSID tell this court that it must act in defiance of the executive branch when it decides that only the interim government is the effective government of Venezuela? The ICSID implementing statute says that you have to treat it as if the award were, and you can never have, it is implausible, and Valores has not argued, the district court did not accept that a state court judgment that had been rendered against Venezuela, in which only the Maduro regime had purportedly acted on behalf of Venezuela, could satisfy the recognition doctrine or due process because, and therefore it would not be enforceable and given full faith and credit in a federal court. There is no dispute about that. And because the statute says, as if the award were a state court judgment, you have to treat it the same way.
I mean, your position really would require us to import all constitutional protections into ICSID proceedings,
Right.
which hardly seems to be the import of the convention and the statute. Because if it's due process and Article 2 recognition, it's everything else. Why wouldn't it be, the 4th, 5th, and 6th Amendments or, basically any other constitutional protections?
Well, Article 2 and separation of powers principles, those are particularly important here because this court cannot do something that is reserved to the executive branch. An international treaty cannot give this court the power to endorse the view that the Maduro regime is the government of Venezuela in contravention of the executive's constitutional power under Article 2. So we're not talking about all US law. And this is a very rare situation. It's not going to be—
Which is the currently recognized government of Venezuela by the US State Department?
the interim government.
Are they officially still recognized by the State Department?
Yes, they are the only recognized government of Venezuela. There has been absolutely no derecognition.
I know that the State Department hasn't recognized the Maduro regime, but does the State Department still recognize the interim government?
Yes.
As the government?
Yes, Your Honor. The latest statements from the State Department is that the National Assembly and its leaders, which is what we refer to as the interim government, is the only recognized government of Venezuela. Thank you.
Morning.
Morning, Your Honors, and may it please the court. I am Miguel Lopez Forastier from Covington and Burling on behalf of Valores Mundiales and Consorcio Andino. This court should affirm the district court judgment for two reasons. First, under the ICSID Convention and implementing statute, U.S. courts are required to enforce the pecuniary obligations of ICSID awards without the sort of second guessing that Venezuela seeks here. Second, even under Venezuela's reading of Section 1650A, there is no basis to deny full faith and credit to the pecuniary obligations of the award here. So let me start with the second point. Venezuela claimed below that it was deprived due process in the ICSID proceeding, and that as a result, the award here was not entitled to full faith and credit. On appeal, Venezuela has recast this as a separation of powers argument to challenge enforcement of the award. Under either analysis, Venezuela's arguments fails. First, Venezuela is a foreign state, and this court has held that foreign states are not persons entitled to due process under the Fifth Amendment. Second, and more important, the ICSID proceedings did afford Venezuela sufficient process. The essence of due process is the opportunity to be heard. And here Venezuela was heard and represented by able counsel acting on its behalf throughout the entire ICSID proceeding, arbitration proceeding. Venezuela has never argued that its counsel before ICSID was incompetent or provided ineffective assistance. There is no allegation or evidence of that here. And as a practical matter, had the interim government succeeded in displacing Venezuela's long-standing counsel at ICSID, nothing would have changed. A different set of lawyers would have argued and advanced the same position Venezuela had already advanced in writing, annul the award in whole or in part. So Venezuela, the state, suffered no prejudice whatsoever from what happened at ICSID. And Venezuela here has not alleged, let alone proven otherwise. Moreover, the lawyers for the interim government dropped the ball in the annulment proceeding. Having the opportunity to file a reply to show why they were entitled to the representation in that proceeding, they failed to do so. So they should not complain now about an alleged lack of due process when they failed to avail themselves of the opportunity they had to be heard on this very issue.
Let me ask you a question about the annulment proceeding.
Yes, Your Honor.
So in order to add those costs and fees from the annulment proceeding, why was Valores not required to amend its complaint to add those additional costs and fees from the annulment proceeding?
I'm sorry, Your Honor, I couldn't hear the first part of the
Oh,
question.
sorry. So why wasn't Valores required to amend its complaint in order to add the costs and fees from the annulment proceeding?
Yes, Your Honor, thank you. Valores was not required to amend the complaint because the complaint already claimed for an award of attorney fees. At that stage, the annulment proceeding was pending and ongoing, and there was a reference to that fact in the complaint. And it was the natural consequence that eventually those fees will be awarded in the annulment proceeding and will be part of the requested relief. The complaint also sought any other such relief that the court may deem just and proper. So it would also be encompassed under that claim for relief. So for that reason, there was no need to amend the complaint. And when Valores did request the court to award those fees before it issued its memorandum of opinion and before it issued the judgment.
But not in its first status report after the annulment proceeding.
That is correct. It did not request in the first status report. And
Do we review the district court's decision on those costs and fees under an abuse of discretion standard?
that is correct, Your Honor. And under that standard, there is no abuse of discretion here. First, for the reasons that I just mentioned, That second, because Federal Rule of Evidence, Federal Rules of Civil Procedure 54C allows a court to grant any relief that a party is entitled to. And that is clearly the case here. So let me go back to the first issue that we were discussing, which is the third reason why this court should enforce the pecuniary obligations of the exit award. The judgment here does not conflict with U.S. recognition principles. By enforcing the pecuniary obligations of the exit award, the district court is not endorsing or contradicting the executive's recognition of Venezuela's interim government. The judgment enforces the pecuniary obligations of the award, not the annulment committee's decision on the recognition of the interim government, or regarding which lawyer should represent Venezuela in that annulment proceeding. Venezuela has been represented by the U.S. recognized government in U.S. court throughout the enforcement case, and the arbitration award debtor is the state of Venezuela, not a particular government. And in any event, the court does not need to reach these questions, since Section 1658 does not empower district courts to review exit awards. Under the full faith and credit standard, so long as exit would treat the award as binding and thus preclusive, so must the district court. There is no question that exit would treat the award here in this way. In other words, Section 1650A establishes that exit awards shall have res judicata effect in U.S. courts. Venezuela's torture reading of the statute eviscerates the provision of its intended effect, since it means that the award effectively has no preclusive effect here in the United States because it cannot be enforced. Venezuela's interpretation also conflicts with the Exit Convention and its self-contained review regime. U.S. statutes must be interpreted consistent with U.S. treaty obligations. And there is no evidence that Congress meant to empower U.S. courts to second-guess the decisions of exit tribunals. All the cases that have interpreted the scope of Section 1650A have held the opposite is true. So, U.S. courts give full faith and credit to state court judgments by giving them the same preclusive effect that would apply in the state's own courts. Because the award is final and binding under the Exit Convention, it must be given the same preclusive effect in U.S. courts. For those reasons, Your Honor, I will conclude my argument. I think I covered the second issue with the questions that you raised, but I am happy to address any other questions that you may have.
Thank you very much, Counsel.
Thank you, Your Honor.
Mr. Perla, we'll give you 2 minutes on rebuttal.
The point I want to make right out of the gate is that this is not a recasting of the arguments made in the district court. Venezuela made the argument about the recognition doctrine in the summary judgment motion, in the objections to the R&R. That's docket number 31, 14 to 15, docket number 34, 15 to 16. But more importantly, the district court itself understood that this was the recognition doctrine, and the violation of the recognition doctrine was a distinct basis for refusing to recognize and enforce the award in its analysis at Joint Appendix 847 to 848, subsection C of the district court's decision. So this is not some sort of recasting of an argument. What happens is that once you deny the only recognized government the ability to act on behalf of Venezuela in the exit proceedings, you are no longer litigating with Venezuela as a matter of US law. And when you bring that judgment, that award to the US courts have to undertake the analysis to make sure that the ICSID award, if it were a state court judgment, would be enforced. And I want to point out the Jimenez case, which is a Delaware state court decision where the Maduro regime came in and tried to exercise shareholder interest over property of a national oil company in Venezuela. And the Delaware court said, you can't do that. We cannot allow you to appoint boards of directors because that would violate the executive's recognition of the interim government. If that,
Is the representation here inadequate in not meeting due process? Was it inadequate in any way other than under the recognition doctrine? I understand you think the recognition doctrine is itself a kind of due process violation. But was there any other due process, way in which the representation was inadequate?
yes, the party that was bound by the award ultimately was not permitted to participate and defend. Venezuela was excluded. As a matter of US law, Venezuela was excluded from those proceedings. So you have now an award that purports to bind the state of
But is there
Venezuela.
any argument that the two different governments have different interests for the state of Venezuela with respect to this expropriation claim?
Well, the ICSID award, under international law, which is not what we apply in the United States for the recognition of government, the executive determination. There may be a decision that there's a decision as to whether each contracting state would have to make a decision as to whether they're going to give effect to to that award in their territories. But in the United States, it is the executive who decides who is the effective government of Venezuela, who is Venezuela. And the interim government is the only entity that is Venezuela.
Your answer is no. There's
No,
no.
yeah, I'm
no
not
difference.
answering the question.
Yeah.
It's
So your answer is
something that we judges would be interested in. Is there some substantive difference that one side as opposed to the other would be looking for?
Well, the representation of the state.
No. In the result, let's go bottom line. Would one side be looking for something different in how the arguments were presented on behalf of Venezuela than the other side? Is there something that went on that was just patently offensive from your perspective? Well, because I couldn't figure that out in reading the record. I'm wondering, what do you add that they didn't try?
We had the representation of the actual party.
We understand the word representation. I'm trying to get you past that. As a matter of substance, were there some points, crucial points that were not being made?
In the
I would add that the briefs were already submitted, proceedings were almost concluded, so that's what we're trying to get at.
Right. Well, let me answer it this way. Substantially the same situation played out in this court in the Rusoro case. In Rusoro, the Maduro regime, when it was recognized by the US government, represented Venezuela throughout the district court proceedings and the briefing before this court. Then the US recognized the interim government. And the interim government came into this court and said, we are the ones we are Venezuela, and we want to argue the appeal. And the same people that were battling it out at ICSID, the Attorney General of the purportedly Attorney General of Venezuela under the Maduro regime, came in and said, no, we are Venezuela. We are going to continue to represent Venezuela here. And this court, in the Rusoro decision, said, absolutely not.
But that wasn't an arbitration.
Was it an arbitration?
That was like a direct, that was a just organic federal court litigation.
But under the implementing statute, it makes no difference.
Is your answer to Judge Rao, no, there's nothing in particular that you can point to other than it was someone different representing the state?
Well, no, Your Honor.
That's okay. If that's your answer, we'll take it under advisement. We know all the rest of your arguments, but be straight with us. If that's it, you can't think of anything, then that's it.
No, Your Honor. In the counterfactual scenario that you explained, there may have been different things that that the interim government could have argued. In our district court briefing, we spelled it out. I'm happy to get that specific site to you. But in the briefing, I believe it's the reply, docket number 31, we explained that there are arguments that the Maduro regime could not advance in the ICSID proceedings because imperi delicto would have prevented them from being able to make those arguments effectively. So there are things that the interim government, which is not, could have argued at that stage that in this counterfactual world that we can't know about because the interim government was not allowed to participate could have made a difference. So that, however, is ultimately immaterial for the fact that this government's endorsement of the Maduro regime by giving full faith and credit and enforcing the ICSID award would be in defiance of the recognition by the executive branch that only the interim government is the government of Venezuela, and that this court cannot do under the implementing statute. Thank you.
Thank you. Thank you. For a lot of the cases